But at the same time, I think it's also worth it for attorneys to begin by just starting soft conversations about.
Good morning, everyone. Today is June 20th, 2024, and welcome to the New Possibilities Hour, part of the Will Work for Food project founded by Natalie Armstrong Motan. Every Thursday morning, Jean Lawler and I are delighted to host another cutting edge webinar for mediators, arbitrators, lawyers, everyone who communicates and negotiates. As you know, there's no charge for these great programs. Rather, we ask people to contribute to a food bank if they like what they see. And so far, our audiences have been so generous in contributing in honor of our wonderful speakers. One of my favorite parts of the program every week is when we announce the running total of just how much our audiences have contributed over the last 4+ years. Jean Lawler, would you please do the honors?
Hi, Jeff. It's a nice number this morning, or today, I should say. 585,321.85 is the number, the amount of donations of which people have told us so far. And that's just fantastic. Thank you, everyone, for your generosity, and the speakers for your generosity of time, your treasure, everyone, and thank you. We'll keep it on going.
Wonderful. Thank you, Jean. Thanks to everyone. Today we have another wonderful presenter, Judge Gayle Williams Byers. She formerly served as administrative and presiding judge of the South Euclid Municipal Court in South Euclid, Ohio, from January 2012 until she retired in July of 2022. During her tenure, she joined the American Judges Association, one of the largest judges-only organizations in North America. Its mission is to provide quality education programs and high-level publications to its members. As a member of the organization, Judge Byers served as president-elect and chair of the Education, Domestic Violence, Diversity, Membership, Social Media, and Technology and Judicial Wellness Committees. Before she joined the bench, Judge Byers served as an assistant Cuyahoga County prosecutor, ending her career as supervisor of the Cuyahoga County Grand Jury. Additionally, Judge Byers has been appointed to serve as the only judicial fellow for the National Judicial College, based in Reno, Nevada, where she has honed expert skills in the area of commercial drivers, licensing, and federal penalties. She teaches courses to judges across the country and provides guidance to the National Judicial College on topics including, but not limited to, judicial well-being and handling commercial drivers in criminal and traffic courts. Since she retired in 2022, Judge Byers has appeared as a television host and jurist on the A&E Network's Court Night Live, where she adjudicated civil matters in a Chicago pop-up courtroom. Additionally, she regularly provides case analysis and legal commentary for Court TV and serves as co-host with retired Judge Tom Hodson on the podcast Next Witness Please, where basic legal parlance and procedure is decoded for the average listener. You can find Next Witness Please on all of the major podcast platforms. Judge Byers received her education at Case Western Reserve University, and we're delighted to have her present today on effective communication during court processes. And I'm sure we're going to talk about effective communication in other contexts far beyond that as well. Judge Gayle Williams Byers, please tell us about the food bank to which you would like people to contribute if they're in a position to do so. And then on with the presentation. The floor is yours.
Jessica Chavin, thank you so very much. And to you all for hosting me. I am so excited to be here. I'm excited also that Cuyahoga was appropriately pronounced or correctly pronounced because most people get it wrong. So I think there may be some Midwesterners in the room. Cuyahoga is located in Ohio. It's actually Native American for the term Crooked River, and it is located in the greater Cleveland area, the food bank for which I am here for today, which is the Greater Cleveland Food Bank, serving multiple communities in the Greater Cleveland area. And so thank you all so much for your generosity, for your commitment, for your overwhelming support for those that are deeply and desperately in need. Your work is amazing. And I just, by the sounds of it, it just sounds unmatched and so very selfless. Thank you. Thank you. Thank you on behalf of the Greater Cleveland Food Bank and every other food bank that has benefited from your wonderful and enduring generosity. So we are here today, and I am excited for us to talk about effective communication and the art and goal of communication in trial settings, in court settings. Here we go. Whether we are ready for mediation, arbitration, or trial. This is an important topic, especially for those who find themselves in situations where you are using or potentially employing mediation and arbitration skills to avert a trial, which is not terribly uncommon. I'll tell you, as a judge, I really do celebrate the work of arbitrators and mediators because it often lessens the load on the court's active trial docket. And when done effectively, I like to say the parties are equally unhappy when the day is done. There's a resolution that is reached, and again, oftentimes the outcome is something that all parties can work through and live with. And so I would caution and I would encourage that if this is your goal, whether to avert a trial or even engage one, any form of communication that you might want to undertake requires the development of a cohesive theme. Develop a theme for your case or a theme for your position. If you have a client or a party that you're representing, it's really helpful to wrap the general idea of your stance around a theme that also becomes a form of a through line, if you will, for the life of the engagement. It helps you to keep things on track, to focus your ideas, to make sure that others are focused and also clearly understand the points that you are making. I would say for litigators, because as introduced, in addition to being a judge, as you heard, I'm also a recovering prosecutor. And so litigation was a part of my life for a very long time. And so it was very necessary for every case that I handled to ensure that there was a thematic overlap to it. Why? Because oftentimes, and especially if I am dealing with a jury, not a judge, I want the jury, the average everyday people who I'm speaking with, who will be responsible for making decisions about this case, I want them to be able to easily understand or to find something in their lives or their common experiences that they can easily relate to. And so themes help you and allow you to accomplish just that goal. And speaking of juries, if you've not had the wonderful pleasure of serving on one, and I'll have to admit that I am one such person, I'm actually looking forward to jury duty. I hope to get one of those fantastic letters in the mail. I'm looking forward to the chance to do the happy dance at my mailbox when I get a summons to appear, because that's never been my experience so far. But in the event that you have had that experience, or you're expecting that experience, or you are going to trigger that experience, then there will be the process of what's called voir dire. Some call it voir dire. It is a French term that means to speak the truth. And if you've been in a courtroom setting and you're preparing and you've developed that theme for your case, remember that this opportunity for voir dire is your one and only chance when you actually get to have a conversation with the people who will ultimately decide your case. Although your jury, once seated, will listen intently, they will absorb information, they will take in evidence and testimony, The only chance you will ever have during an entire trial process to hear their voices and to have them talk back to you and to answer questions that you specifically ask them is during this voir dire process, which is what makes it so very valuable. You actually get to hear their thoughts. You hear their positions. You hear their suppositions about things that are important to you, your client, and your case. And because of this exchange, because of this conversation that you're able to have with potential decision makers, as the person responsible for deciding who sits on that jury, or at least partially responsible for deciding who sits on that jury, you can now make an informed decision about whether or not you believe this person would make a good individual for this case. Now, I do caution, and as judges, we do this frequently. We caution potential jurors that when the time comes that they have been excused or they are no longer asked to serve as a result of the voir dire or the questioning process, it does not mean that their ability to make good decisions are questioned, or even that their fairness or maybe even objectivity is questioned. It just means that for this particular case, in this particular circumstance, they may not or do not seem to present as the optimal or best decision maker out of all of the jury options available. They just are not one of the best options that present to be available. And there's nothing wrong with that. Actually, some people might actually be happy that they weren't the best ones to make the decision, while others may be somewhat disappointed while that process has taken place and they've engaged it rather intently and genuinely. But voir dire is, again, a wonderful opportunity. And I encourage anyone having a trial process where you are engaging potential jurors to really, really take this seriously and to make sure you use this time to truly vet your potential jurors, to get them to talk back to you, and to make sure that you can get more information than what they may have included on a mere questionnaire, because I promise you the questionnaires are not designed to be full. They're not designed to be complete. They're not designed to be comprehensive, but your questions can do all of that. Now that you got your jury seated, the next thing that you have to do to effectively communicate with them is to make them believe in you. Remember, there's a reason why you showed up with a theme. There's a reason why you specifically picked them. And there's also a reason inside of this communication why you believe that you can convince them as to the efficacy of your side or your experience or your client's position. And your job now moves from being able to have that conversation, that back and forth with those jurors, to really, this is a one-way communication. It's almost like sitting there and talking to someone and almost therapeutic, right? Yeah, how many times have you been seen a therapeutic environment where the patient or the client is doing all the talking and the therapist is only taking the notes, never saying a word? Well, that's almost how jurors are going to respond to you after they've been formally seated. They won't talk back to you. They may take copious notes, but your job is to be able to read other communication cues that they may give you. This could include body language. This could include eye contact. This could include head nods, or this could include falling or nodding off to sleep. Your responsibility in your communication is to ensure that you are always speaking and communicating in a way that is clear, concise, lively, engaging, and ensuring that it's understandable. Now, no doubt you're going to have times when the subject matter is not always the most exciting. And so there are certain tools of the trade and certain tricks that can be used to help ensure that you can get through what are commonly referred to as rough patches, where you know that jurors may find it difficult to hear certain things. For example, this tends to be common when testimony or information is very, or highly scientific or highly technical, where the average juror may not possess an intrinsic skill set where they understand or appreciate the technicality of the subject. That can sometimes solicit boredom, or it can cause jurors to nod off. It can also cause them to disengage. What you want to make sure in your communication is that you are always engaging them in a way that they feel connected to you, that they believe what you're saying, and that you can all but essentially take them by the hand and guide them through this journey, and this experience, such that by the end of the experience, they have no choice but to continue to trust and believe you and to deliver an outcome that you are desirous that they will. So whether it's in favor of your client or in favor of the state or the defense, the idea is that at the end of this communication, you would have been able to all but essentially guide them along, taking them and getting them to the point where they are trusting you to the end and delivering what you desire. Well, that goes right along with how you frame one of the first things you'll do. And one of those first things is, after jurors are seated, they've become comfortable with you. You've asked them questions, they've given you answers, you have vetted them. Some of them have remained, some may not have. And now you deliver your first thematic speech, your opening statement. The goal of this, which is a golden opportunity to essentially begin an indoctrination process, is to articulate your theme very clearly. Nothing that is so complex that your jurors will find it difficult to connect to the heart and the evidence of your case. And so that theme you developed very early on will now flow through into your opening statements. You may have even hinted to this theme during that voir dire process while you were asking questions, maybe about the juror's background, their beliefs, their inclinations. Well, when you get to the opening statements, you know exactly who you seated, and you know exactly who the decision makers are. You're very familiar now with what their positions are with regard to the things that matter to you and your client. And now you're prepared to open up and to show them the full theme and theory of your case and your presentation. And so your opening statement, although not evidence, is an opportunity to do just that. And it can be an opportunity that is golden and is utilized optimally when rehearsed and delivered with perfection. And so the goal in communicating here is not just the verbal words. I submit that when delivering these opening statements, ensure or understand that there's an awful lot that goes into this perfect delivery. It is the theme indeed, but it's also the comfort level that you now exhibit with your new audience, which are the jurors. It means that you engage them. If there's a podium in the room, abandon the podium and become more personable, not by stoically standing or clasping the podium as if it were a vice or death grip, but gently move away. Become personable with your audience, deliver your thematic statement with authority, make eye contact with your audience, which again is another form of communication. These are all forms, because the goal is to, again, exude not just that authority, but also to begin to develop that trust and to begin to develop that sense from your audience that they can rely on the information that you're now promising in your opening statement to disclose or reveal to them throughout the body or the nature or the experience of the trial itself. This is so important because whatever you promise them in this opening statement will become that much more important when you move to the latter or additional stages of the trial, which begin with direct examination. Direct examination is actually the initial, what I like to call storytelling opportunity. But the trick is, it's not your storytelling opportunity. It is your witness's storytelling opportunity. And so, for as much as the communication is important for the part of the attorney, it is equally, if not more important, that you prepare your witnesses to communicate effectively with this same audience. I'll give you an example. When I was a prosecutor, I would often have cases where I knew for a fact that I would have witnesses who had no prior courtroom experience or very limited courtroom experience, and that the current courtroom experience would be pretty unnerving for them. It's not common that you'll be able to get a mock jury in so that they can practice and become comfortable. And quite frankly, even if you could, that isn't always a good substitute for what will really happen on the day of or during the actual trial experience. But what I could always count on is I could always count on the fact that I would spend enough time with the witness that I could develop a relationship with the witness that, just like with the jury, the witness would trust me. And so in most courtrooms, you might notice that if there is a jury, the jury box is generally seated next to and closest to the witness box. And that's on purpose. And with the witness being as close in proximity to the jury box, the goal is that the witness will testify or tell their story or communicate directly with the jury. Remember, you already know the story, so you don't necessarily need it yourself, but the jury needs the story. And so I would have a little trick that I would use, and it was a positioning trick, also used to, again, encourage effective communication from witnesses, where I would stand on the direct diagonal from the witness box, right diagonally across at the edge of the jury box. And I would ask my questions to the witness all the way across the room for multiple reasons. First of all, from that distance, it required the witness to speak loudly and clearly, because you'd have to be able to hear them in order to send and receive the questions. But the second reason would be it would always force the witness to look to me, the trusted face, to tell the answer to. And it would give the at least illusion that they are communicating directly with the jury. And so, with them looking to the jury, it actually achieved the goal of having that direct examination, asking open ended questions, and ensuring that those open ended questions are answered by the witness directly to the jury. So I would always teach what I called baby prosecutors that the only questions they ever needed to really ask on direct examination were the who, what, when, where, whys, and hows. That's all you need to know. Every question should start with one of those words because it meant your witness needed to fill in the blank and that they were actually telling the story and that they could tell their story in their words directly to the people who would make the decision, which was the jury. And just like I was building a rapport with the jury, I could use the witness to build a rapport and a relationship with the jury. And that was generally very, very effective. Now, we all know, and hopefully we know, direct examination isn't the only kind of examination for your witness to experience. And it kind of softens them up only for them to have a very interesting experience shortly thereafter from the person waiting on the other side of the room, which is the cross examination. And I love this picture because this is a perfect example of what a cross examination actually looks like. Everything from the very close face to face between the attorney and the witness to there's no appearance of almost anyone else being in the room. And the reason is because cross examination is also an essential form of communication because now it is designed to take that spotlight off of now that empathetic, articulate, jury focused witness and place it squarely on the questioner, who is the other attorney. They're never or hardly ever going to ask a question that starts with who, what, when, where, why, or how. In fact, almost every question they ask is going to imply an answer, almost as if the witness fades into the background and is supplanted now by the attorney who's doing a lot of the testifying. And so that means the questions that are asked also need to tell a story all their own. This is how alternative theories are developed. This is how defenses are developed. This is how other ideas are brought to light, often through effective cross examination, where the idea of something alternative is made clear. Not by the witness, because all the witness is designed to do in that instance is agree with now what essentially becomes the testimony of the attorney using cross-examination, which again is probably one of the most powerful tools that can be used because a good cross-examination can completely undo and unravel even some of the most effective direct examinations. And so if you're ever wondering, how in the world did that wonderful witness now end up leaving the witness stand in tears? It's likely because the attorney who conducted the cross-examination was ready to undo all the hard work the attorney had done previously and to develop a theory of the case essentially through their own testimony, using that witness, but through their own testimony that completely unraveled everything. Once both sides have presented, and that's generally the case, especially if there's a civil matter, if there is testimony to be submitted on both sides, then comes the closing argument. Well, closing arguments are an opportunity to remind the jurists of the theme of the case. It's also the greatest and best opportunity to remind them of what has been promised at the beginning during that opening statement, to continue that through line throughout the life of the trial with witness testimony, exhibits, and any other evidence that may have been submitted, and then reaching into closing arguments with the reminder that what was promised was delivered. And because of that, the jurors must, in fact, trust you. And because they trust you, because you have thoroughly explained and communicated. You've not over communicated. You've not saturated them with legalese. You have not inundated them, and you've not belittled or treated them as if they are unable to understand. But instead, you've brought them all the way through this experience. And by doing so, they simply must trust you to the end. And by doing that, they will find in your favor or follow the request that you make. And so that can be a finding on behalf of your client or that could be delivering a particular verdict one way or another. I was talking to my co-host of my podcast, Next Witness Please, and he tells me the story of how there were times when he would have a criminal defendant client, and he actually used his suiting as a form of communication. He said that he would come in, and the first day he would come in, he'd wear the darkest suit he had in the closet. Why? Because in most criminal cases, whether you like it or not, the defendant may be cloaked in innocence, but there's always someone there who's got that tinge of sense that maybe they did something. And so he said what he'd do is he would develop his theme early on. He would reinforce it day by day with the defendant throughout trial, but he'd also couple it with what he was wearing. So although he'd start off on day one with the darkest suit, with each successive day, his suit would get lighter and lighter and lighter, such that by the end of the trial, he would be wearing the lightest suit he had in his closet, even if it was the middle of the winter in the Midwest, because the idea is that not only is he communicating with his words, he's communicating through his clothing to show and to demonstrate that the defendant has moved from that cloak of that tinge of perhaps guilt to truly being innocent. And he would stand next to his client while delivering that closing argument in that very, very light colored suit, so as to provide, again, a different layer of communication, a different layer and cloak of innocence over his client. And he says that it has had many times been very, very effective when coupled again with delivering a dynamic closing argument. And so I like to say, as I indicated before, one of the most profound things you can do, especially for decision makers, whether they're judges or jurors, is showing respect. And respect comes in a lot of different ways. It means, yes, communicating clearly, articulately, frequently, but also in a way that they can understand. If you understand and appreciate that your audience, being a jury, are not individuals who are overly or specifically trained in legalese, then shy away from using too much legalese. In fact, it can come across as overbearing, disrespectful, and out of touch or out of tune. If you are going to use legal terms, define them and make sure that the definitions are easy to understand, and explain to your audience why you need to use that particular term and why it is important for them to understand it. There may be a very particularized reason as to why that's necessary. But if you're using certain terms only for the sake of making yourself feel better or to look grand or grandiose to your audience, then it comes across as actually very disrespectful to the recipient, respectful of their time as well. Understand that again, after voir dire, these people can't talk to you. They can talk to the judge, but they can't talk to you, and they can't really tell you what they're really thinking. And oh my gosh, if we can crawl into their heads, maybe we don't want to know what some of them are thinking. But it would be really helpful to appreciate that we want to respect their time. Yes, we have goals we want to achieve, but if you've made a point, then make your point and move on to the next point. If it's worth revisiting that point, then find a clever way to revisit that point. Use any type of demonstrative implements that may be helpful in doing that. But respect your audience enough to understand that if they are permitted to take notes, they've taken notes if that's an interest. Also, if there's a jury, there's a deliberation process. So they often rely on their collective memories. So what one person didn't hear, another person very well may have, and they're happy to rely upon that. But belaboring points and diminishing individuals with using language they're not familiar with is often a turnoff. I'd also say show respect to opposing counsel and other parties in the room. There are no trophies for being unkind. No one's going to throw you a parade for however many times you can cut off the other guy mid-sentence, or how many times you can berate a witness or another party, or another individual. If the decision makers see that you are showing respect to others, I promise this will factor into their decision making and how they view you, not just as you present in this case, but as a person. And believe it or not, it actually matters to them about how they view you as an individual. And finally, don't ever let them forget the important stuff. If you have important information that you want them to hold on to, then use every tool available to you to make sure that that message gets across. What could that mean? Well, in this day and age of technology, that could mean everything from your stellar opening and summation or closing argument, to using video evidence that is played again, to using whiteboards or dry erase boards or other exhibits that will certainly assist them in remembering and understanding not only the theme, but the facts as they have been laid out. Do not allow your decision makers, whether it's the judge or jury, to draw or create alternative facts when you have all of these tools readily available to demonstrate and to show and to remind them, so that your point, your position is well appreciated when it comes time to making the decision. Oftentimes, even now, jury deliberation rooms are equipped, they are highly technologically sophisticated. So they have computers, they have screens, they have dry erase boards. You can utilize any one of these tools to remind them of the information you want them to have locked in their memory when it comes time for you to decide, or for them to decide the case, preferably in your favor. And so, if that is your goal, these are pointers I would encourage you to take to heart, because it's so necessary that when they are making these decisions, the important stuff is not lost. You don't mind if they lose track of a few other things, but you don't want them losing track of the important stuff. Those are my tips. I think I've gone just a little bit to the halfway point. I'm going to turn it back over to our hosts, and I'd love to invite a conversation and a discussion about what you've heard and how I can perhaps add value to what you're already doing, or provide you some more insight as I've had experiences in. You.
Thank you, Judge Williams Byers. That was a comprehensive and fabulous presentation drawn on the depth of so many years of your experience as a judge. Let's turn it a little bit in terms of communication. Let me ask about communications between lawyers and their own clients. One of the things that we often find in mediation is lawyers coming to us as mediators and asking for help with the management of client expectations. That clients sometimes develop an overconfidence in their case, that perhaps the facts and the law and even the degree of confidence they have in their own attorneys doesn't really justify. What insights can you give us on secrets of communications between lawyers and their own clients to instill confidence in the clients, but not so much that the clients become overconfident and perhaps unable to settle their cases or deal with the situations realistically?
I think you have asked a phenomenal question, and you began it perfectly by saying two words: expectation management. It is so important to manage the expectations of your client at the outset. First and foremost, consider the fact that your client has knocked on your door for a reason. They have either been referred to you, they've somehow found you, but they trust you enough to show up. They believe that you have a history and a reputation that precedes you and is worthy of their time in their case. That means they've already bought into your abilities. And so you can rest assured that your abilities won't wane because they've appeared at your door. And they can be reminded that you have a successful track record. However, it's worthy of a discussion with your client to let them know very early on that every case is unto itself, that successes are based on the cases, that every case is different, and that their case may in fact present or begin presenting in one way, but that no one, that very rare is the occasion when we haven't been surprised by something. Surprises happen. And that when or if they do, that can actually change the efficacy of a case. It can change the likelihood of an outcome. There are other things that can affect the likelihood of an outcome. Let's just be very candid. Sometimes judges, sometimes getting a certain judge that you believe may have a certain belief about certain types of cases can affect how you deal with your client and your client's expectations. My suggestion would be have conversations with your client as often as possible, especially when there are changes in the case. Your client may believe that things are going along swimmingly. My lawyer's fantastic. He's already promised me we're going to win. Let's go out here and price the yacht right now because we're going to be on Easy Street by next week, Tuesday. And lo and behold, the closest they're going to get to Easy Street is a lotto ticket that may or may not be worth what they paid for it. And so what you have to do is you have to have that conversation and say, listen, although I have all faith in your case, which is why I've taken it, we have to also appreciate the fact that that cases change all the time. If there are things about your case that change, we need to have a conversation, and that may change what the outcome is. It may change our strategy. I will give you my opinion. I need you to make a decision, but I also need you to trust me when I give you an opinion about that change strategy, and I will explain why that opinion is. Sometimes our clients don't understand why we're suggesting a different strategy for their case. And they may have these notions in their head as to whether or not the lawyer's doing it because they just don't want to do the hard work, or does the lawyer know something that I don't know and they're not willing to share? Well, the truth is, may just be that, you know what? Something just blindsided us and we didn't know about it. Once we learned it, we've got to move a different way if there's going to be any success in this case. And your client needs to know that. And if you can manage their expectations, then I think you have good outcomes every single time.
Let's zoom in on that a little more closely and ask about lawyers in their initial communications with consumer type plaintiffs, people who are not seasoned in the legal system, perhaps, people going through a divorce, people who've been in their personal injury plaintiffs, or perhaps employment discrimination plaintiffs. And the contingency fee lawyer is concerned that if you don't promise this person that you're going to put them on Easy Street a week from Tuesday, somebody down the street will, and you're going to lose the client. So what advice do you have in those specific situations about approaching clients with the proper balance?
And I think it's important to discuss with the client first of all, the lawyer's ability to address the concerns that the client presents with, that they are not presenting with something that the lawyer cannot handle, but also understanding that they deserve to have representation that is honest and transparent with them. And so if you are telling them something about their case that may not seem appealing, but someone down the street who's promising them Easy Street by next week, Tuesday, they are also not being transparent with them. Anyone who overpromises without being transparent enough to explain the pitfalls or the challenges of the case is doing a disservice to their client, because they are not providing them with the full breadth of information they need to make intelligent decisions about their own case, even when they are represented by counsel. Now, I think attorneys can also say, I will advocate for you. I will be zealous in doing so. I will put forth all efforts and I will be strategic. There are an awful lot of tools in the toolbox that we can use. We can refine things. The pivot is not difficult. It may be different and it may be necessary, but we have the ability to pivot a lot of different ways depending upon whatever turns your case may take. But anyone who promises you a straight line with no challenges, no issues, no concerns, or nothing to ever worry about is probably someone who's not being particularly and fully honest with you. And what I want to be is that. I want to be honest. I want to be transparent, but I also want to allay your concerns and tell you we've got a whole lot of tools to deal with whatever may come our way. And so we can be ready for this and we can get through this. Let me handle the problems. You just trust me. But anyone who's promising you otherwise is probably going to disappoint you because they're not being very transparent.
And I suppose if you lose a client, prospective client under those circumstances, you may actually just have saved yourself a big headache down the road.
Probably a disciplinary action. Because also consider the fact that if you lose a client after you have committed to using all the tools that are available to you, and you have committed to, of course, zealously advocating for them and holding their best interest at heart, and they are still not satisfied, trust me, this is probably the client who's not going to be happy no matter what you do, no matter what efforts you've undertaken, and no matter even the outcome. They're also probably the client that will spend your entire time together looking for a reason to complain about you to your bar association and potentially, challenge your ability to maintain your law license, which is more work for you, and it also causes more challenges for the attorney who really does want to be there to zealously advocate for their client. So you're right, it's probably the one you'd want to send to the dishonest lawyer down the street or the other lawyer down the street. You might want to call them up and say, hey, I have a referral and I won't even take a fee. You just take the client.
Right. What was the old joke? Henny Youngman, take my wife, please.
Exactly. Exactly.
Yeah.
Have the client, you want to call them up and say, hey, you need somebody?
Right, right. Let's talk a little about communication between lawyers. As mediators, one thing that we still hear sometimes is that lawyers are concerned about raising the subject of settlement with opposing counsel because of a concern about appearing weak. What,
Mm.
what are some effective ways you've seen for lawyers to raise the subject of settlement, prospective settlement with opposing counsel, and still appear strong and confident?
You know, and maybe it's because of my position as a jurist. Um, I know that I've at least heard attorneys say, I would love to resolve this matter, wondering what your position might be. Because did you know this judge likes to try cases on Friday mornings in the middle of your golf season? Doesn't mention weakness at all. It has
Uh-huh.
everything to do with how would you like to spend your Friday on a very sunny day, because this judge, our only other option is to go and deal with this judge. How would you like to do that on a Friday, starting at 8 a.m. and miss the whole day and potentially, make a whole jury angry because no one wants to be here on a Friday? But I'll also, and that's just me kind of tongue in cheek, because that actually is when I would really set trials, on Friday mornings at 8 a.m. And I promise you, I got a lot of things resolved. And I would say we're going to go on a Friday morning. And especially in the middle of the summer, which is when everyone wants to enjoy the sunshine. Everyone. But at the same time, I think it's also worth it for attorneys to begin by just starting soft conversations about case assessment, what information do you need? What information is still outstanding? I'd like to have a conversation about where we're going with this. And, what do you see as an appropriate resolution? Have you had a conversation with your client about what a resolution looks like? And I'm not suggesting settlement. I just want to make sure that we're all on the same page. Those kind of become code words and phrases for the settlement term without directly saying that, but it can begin to soften the ground, if you will, for those subsequent discussions, especially if you know that you're sitting in the catbird seat and you've got everything that's needed to get this fully resolved. And maybe it's taking a little bit of time, and not just expectation management. You probably know best that sometimes attorneys deal with some client management. It's not just the expectations, it is the actual client that they're trying to manage and deal with, their personalities, or their potential responses, the extending over and above. And sometimes they may themselves not be ready to have that conversation with a client that is not quite prepared to act like an adult, if you know what I mean.
Yes, yes. Well, let's let's zoom in on that a little more, because we know that in every single settlement ever recorded in Western civilization, the defendant has paid more than they think they deserve to pay, and the plaintiff gets less than they think they deserve to get. So when
Two
you're
equally unhappy people.
well, I phrase that a little differently. They may be unhappy with the financial term of the settlement, but at the same time, there are other dimensions of the settlement: getting it over with, getting the headache out of your life, not having to pay lawyers anymore if they're on an hourly basis, eliminating the risk of a disastrous result. And if the utility or benefit of those other dimensions outweighs the disappointment with the financial term, then on balance, it's a good settlement. And
Hmm.
people should enter into settlements only when overall they're happy with them. They're better off with them than without them. But at that crunch time, when the client is really confronted with having to pay more than they think they should pay or take less than they think they should get, what are some helpful things that lawyers can say to clients to get them over that last hump, to do what the lawyer knows is in their best interest logically and reasonably?
You know, you actually hit the nail on the head in speaking to all of those other, what I like to call collateral or ancillary benefits that are completely unrelated to what the client may see as the bottom line, right? So if the bottom line is, hey, I paid out more than I wanted to settle this case, or I settled for less than what I wanted to out of this case, what I think a good attorney does is they actually walk their client through all of the other benefits that they derive from case resolution, that they may not realize that they're deriving. Understanding that, yes, as a defendant, maybe you felt like you paid out more than you should have, but remember, you're still paying me to represent you. And now this becomes an expense that you no longer have. Remember that you've been trying to, maybe take your life in a different direction, and you felt stymied or you felt stuck because you've been in this vortex of litigation, or you've been here handling this matter. Well, with this resolve, you actually walk away with a sense of peace and resolution that you've not been able to enjoy for the period of time that this has been pending. So you really can turn the page and you can move on. That has got to be worth its weight in gold. You can actually, maybe you see your therapist about something other than this case now. Maybe you have a discussion at dinner with something. Maybe you lament over something other than this because this has consumed you and it's taken over. And so now you have the benefit of actually being able to enjoy a stroll outside without talking to yourself endlessly about how much much you absolutely hate going through this experience, or how much money you're hemorrhaging, or how much time in your life you're losing, or how you've called your attorney and you're not getting your calls returned at 3 a.m., although their office closed at 5 p.m. the night before. These are the things that you can actually free yourself of and you can move on. And I think, again, that sometimes when litigation consumes someone where it's not this isn't their everyday experience. Most folks that attorneys work with, they are experiencing this singular thing in this singular moment. This is the work that lawyers do every day. But for the folks we work with, this is a moment in time for them. And so getting them to understand the benefit of recapturing or reclaiming their lives and their time, I think, my mother's from the South and she has a whole litany of sayings. And so she would probably say to me, you know what? All currency ain't cash. And so, in this instance, explaining to your client that all currency is not cash, there is currency to resolving this. It comes in the form of getting things back that you didn't have. So, take the win.
Mm-hmm. So the final question that I want to ask you is taking that, how can we coach the clients to take that message back to the people to whom they have to explain, right?
Mm.
It's many times a spouse, it could be a business partner, a therapist gets paid to listen to this stuff. So that's a different question. But there could be a spouse or business partner, family member, and when a client is paid more or taken less, I think that there's a fear that they'll go back to that family member or spouse and say, well, for this and that reason, I I paid a little more, I took a little less. And the spouse or family member will say, you did what? After what they've put you through? But what that family member really means is, you did what? After what you've put me through. So how can we coach the clients to have those conversations back home?
I think there are multiple ways to address this, and I think your point is spot on by saying when you have to be the messenger at the conclusion of an experience, you have to be prepared with the message, similar to how attorneys have to prepare to deliver their message, whether they're in court or they're in mediation. And I would say, first of all, for the attorney, prepare your client for every stage of the process. If you believe you're getting near or to the end, or you're preparing to resolve it, prepare them for this. Hey, listen, I think we're probably going to be out of the woods in another 6 months or so, or we're going to be maybe wrapping this up in a few short weeks. That helps to manage their expectations for how much longer they need to hold on and maybe how many more copays they've got to give the therapist. In the meantime, it's also helpful to coach them into having an end game, if you will, similar to something you just said. Hey, listen, I'm your attorney. I won't be representing you after this. You surely can call me if you ever need my services again, but we won't really have this level of communication after a few short weeks. What are your plans? What are you going to do when you get rid of me? What are you going to do when this is all over? Do you have something that have you talked about this with, your business partner? Do they understand that this is where we are? Extent that it's appropriate, it may even be helpful to say, if you're willing to waive the privilege and you're comfortable with it, I'll have a conversation with the important players so that everybody understands where we are on this. And I think that maybe you should plan something for yourself that just says, hey, I got this over. I don't care if it's a nice dinner, if it's, a stroll down to the local boardwalk, or if you're going to finally take the vacation you've been putting off because you haven't been able to decompress in a year and a half. But you should be prepared for the fact that this is going to be over. I'll tell you what, you're absolutely right in that there's always someone on the other side of these cases that kind of takes the abuse and they become kind of the stand-in therapist even when they're not getting the copay. that's the person who's probably most angry about however it turned out. And not because they believe they're F. Lee Bailey's cousin, not because they think they're the better lawyer or they could have gotten a better deal, but because you're absolutely right. They have walked this journey with someone the entire time. And now they are wondering, what the heck? And so prepare them for it. Hey, your business partner, are you guys going to go celebrate? Are you guys going to have dinner? I realize that you may feel like you paid more than you may have wanted to, but I'm sure you got enough left over to go to the nice steakhouse, cling some glasses together, and say, we put this one behind us. Take your spouse on that, weekend cruise that you guys have been putting off for the longest, because guess what? You got the X out of your picture. So you are now free to live your life the way that you intended. These things can be decompressing and relieving, but I think that sometimes the abrupt stop of cases don't really prepare people to pivot to the next page. And so we can help them get there by giving them just a few short tips on, hey, this is what's coming. And maybe you ought to be ready for it or start preparing yourself for it, because I'm not going to be here to hold your hand. I will take the money, but I won't be here to hold your hand, and we'll make sure that you're going to be okay when it's over. But call me for the next case.
It almost sounds like the kind of uh, training prisoners get when they're released from prison, because litigation for some people does seem like a jail sentence. Judge Gayle Williams Byers, thank you very much. You come to us from the Cleveland, Ohio area, home of the Rock and Roll Hall of Fame. And whether or not you're in the Rock Hall of Fame, you're in our Hall of Fame. Thank you
Thank
very
you,
much
sir.
for a terrific presentation. We hope that people are able to support the Greater Cleveland Food Bank. That's www.greaterclevelandfoodbank.org, www.greaterclevelandfoodbank.org. Thank you very much, Your Honor. And with that, we are complete.